Hi, everyone. My name is Bianca Bourgeois, and I work for the Graduate Programs Office, Faculty of Law at McGill University. In an ongoing series of webcasts, we'll be introducing you to professors in our faculty and exploring our graduate programs in law. Today, I'd like to welcome Professor Ram Jakhu, who's here to offer a presentation about his research to us. Professor Jakhu is a tenured associate professor and acting director of the Institute of Air and Space Law at McGill. We specifically offer a Doctor of Civil Law, Master of Laws, and Graduate Certificate in Air and Space Law. Professor Jakhu currently conducts research and teaches 3 graduate courses related to international space law of space applications, and national regulation of space activities. He's also directing an international research project relating to drafting the McGill Manual on International Law applicable to military uses of outer space. Professor Jakhu, thank you so much for joining us today, and you can begin your presentation whenever you'd like.
Very much, Bianca. Thank you for your kind introduction. Greetings from McGill University in Montreal, Canada. I would like to share with you my views on a significant and urgent challenge in the exploration and use of outer space. This issue relates to rapidly growing amount of space debris. I would discuss this issue from a legal perspective. That is, means to what extent the law has been successful and where it failed to effectively regulate space activities and particularly space debris. In order to better understand the legal aspect of space debris, I will explain how the problem has arisen, how serious it is, what would be the implication if the problem of space debris is not resolved, and how it is being regulated, what is the main inadequacy of the application of lex lata, and what should be done to develop lex defenda in order to control or minimize space debris. Additionally, in order to place this problem in general context, I will begin by outlining the importance of space for the humanity. This presentation is essentially in the form of one of the lectures I give in space law. However, in the interest of time, the content of what is normally a more interactive, comprehensive 3 hours lecture has been shortened to about 20-25 minutes overview. So, how important is space for the humanity on Earth? Modern lives, particularly in the developed countries, depend heavily on space-enabled technologies. Space is simply indispensable and integral part of modern societies and economies. Our reliance on space expands from the use of cellular foods to the provision of navigation, banking services, weather forecasting, climate change monitoring, agriculture, urban planning, protection from forest fires and other disaster management, the monitoring of major human rights violations, verification of disarmament agreements, and many more other applications. In purely economic terms, the current global space economy is worth around $400 billion annually. Some studies predict the space economy may increase to more than $1 trillion annually by 2040. Satellite supports other industries which generate additional trillions of dollars in revenue and create millions of jobs around the world. More significantly, these benefits are expected to increase exponentially and expand globally in the coming years. Nowadays, we take the space-related benefits for granted. We can hardly imagine that the day without satellites could be chaotic at best and disaster at worst. However, it is said that throughout history, major technological innovations hold the potential to create disorders, mainly because of the abuse of technologies and their applications. And space technology is not an exception to this. What are the current challenges in space exploration and utilization? There are several challenges to global space regime, but the most important of them relate to, firstly, increasing weaponization of space and the possibility of war in space. Secondly, unilateral exploitation of space and natural resources. Thirdly, exponential demand for and potential conflicts related to radio frequencies plus space services. And finally, rapidly growing number of pieces of debris in outer space uh, around the Earth. And I will focus on the last challenge. But what is space debris? Simply speaking, it means junk, rubbish in space. Formally, it has been referred to as, I quote, all man made objects, including fragments and elements thereof, in Earth orbit or re entering the atmosphere that are non functional. Though this is not a legal definition, but this is generally accepted for conversation, even for regulations in general. How this problem has arisen, how space debris is created. There are several sources of space debris. They include dead satellites, upper stages of launchers remaining in space, operational debris, aging material in space, and fragmentations. Fragmentation debris is created by accidental collision between objects in space. And the most important example of such collision occurred in February 2009 when debris from dead Russian Cosmos 2251 satellite collided with an active American commercial satellite called Iridium 33. This collision created a large cloud of space debris and disrupted communication services to a section of Iridium customers. Another major and growing concern is the creation of debris from intentional destruction of space objects. This could, for example, be the result of the testing of anti-satellite weapons. The most prominent example of this happened in January 2007, when China destroyed its own dead weather satellite. The incident created thousands of pieces of debris and was considered to be the worst satellite fragmentation in the history of space age. Similarly, in January 2019, India conducted an anti-satellite weapon test and created hundreds of pieces of space debris. So, what is the current space environment like? Currently, there are about 23,000 human-generated objects measuring from 10 centimeters in diameter. In addition, there are at least 500,000 untracked objects between 1 and 10 centimeters, and more than 100 million untracked objects between zero point 0.1 and 1 centimeters. Particles measuring less than 0.1 centimeters are more they're in abundance. As you may know, objects orbit the Earth at different heights. Closer an object is to Earth, the more Earth's upper atmosphere creates drag effect. And that slows the objects down and reduces their altitude. In time, such objects will eventually re-enter the atmosphere and are destroyed through a process known as natural decay. However, more objects are being launched into higher orbits, meaning they are staying longer in space. While natural decay may cause space objects at low orbits to re-enter, this natural decay process is not very effective for space objects located at higher orbits. Several companies, commercial companies, are pursuing the launch and operation of various networks of tens of thousands of small and medium satellites. SpaceX, for instance, is planning to launch more than 30,000 in the coming years. Such mega constellation will be further increasing the problem of congestion in space and space debris. Then the question arises how serious the problem is that has been created by space debris. For about 63 years, humans have been launching things in space, giving rise to the problem of space debris. The situation is becoming very messy and dangerous. According to the 2011 US National Research Council report, space debris has already reached a tipping point. That means even if no new space objects are launched, space environment, at least in the most used Earth orbits, might not be sustainable on a business as usual basis. Due to the high velocity at which space objects travel, space debris can damage or even destroy an active satellite or injure or even kill an astronaut. Even particles as small as a few millimeters can inflict heavy damage or completely destroy an active satellite. For instance, on July 24th, 1996, the French microsatellite was hit and damaged by a fragment of the third stage of Ariane rocket. On May 23rd, 2013, a collision between a piece of debris from the Russian rocket destroyed Ecuador's small satellite. International Space Station, which is the only inhabited station in space nowadays, has been maneuvered to avoid collisions with the pieces of space debris. In 2019, 2020, several hundred space debris collision conjunctions were issued. This means this space operators need to maneuver their objects, wasting fuel and potentially also reducing the lifespan of their active satellites. Space debris can also severely injure or kill people after falling on Earth. In 1997, a lady in Tulsa in the United States reported that she was stuck on the shoulder, falling from debris while walking. It was later confirmed that this piece of debris was a part of the American Delta II rocket. There are also serious risks for spreading radioactive or toxic material on Earth should debris re-enter uncontrolled. In the past, there have been 10 cases of failure leading to scattering of radioactive material on Earth. In 1978, highly radioactive uranium 235 from piece of debris of the Soviet Cosmos 954 satellite was scattered over an area of 124,000 square kilometers in northern part of Canada. In order not to worry about global warming, it is often said that sky is not falling. However, in the case of space debris, I'm of the opinion, I believe, the sky has in fact already started falling. The question is who should be aware of or concerned about risks posed by increasing space debris? In my view, firstly, the general public, which could be losing many benefits of space utilization if space debris becomes uncontrollable and remains essentially unregulated. As mentioned before, the destruction of active satellite can disable communication across the globe. Imagine the severe consequences if debris were to destroy a navigational constellation like GPS. Individuals could also suffer injuries, even death, and endure damage to their property. Secondly, the states must be aware and concerned about space debris risks. According to international space law, states are internationally responsible for national space activities, including those carried out by private companies. This means the states are held liable for damage caused by space objects, including space debris belonging to their private companies. Thirdly, my view, legal advisors and practicing lawyers should be aware of the risks posed by space debris. A legal advisor needs to know that the government he or she represents could be held liable if damage is caused by space debris from a national space object. Understanding this issue would allow the advisor to advise the government accordingly and also prompt governments to pursue international efforts for the adoption of legal mechanism for regulating and mitigating space debris problem. Practicing lawyers, especially in demand to the flourishing commercial space industry, needs to be aware of risks and liabilities posed by space debris in order to properly advise their clients in order to take appropriate measures that could be taken by them. For example, taking out sufficient insurance. Practicing lawyers should also be aware of business risks posed by space debris. He or she needs to make sure the contracts for satellite launches, selling of services, and financing of space ventures contain appropriate clauses protecting their respective clients. Now let's see to what extent space debris has been regulated at international law. So what is the lex lata on this issue? Existing international legal frame governing space activity must be considered from the perspective of the legal consequences should the risks posed by space debris materialize. Secondly, such regimes should be examined to identify international legal obligations to take preventive measures in order to address and mitigate such risks. Two main space treaties regulate legal consequences of risks posed by space debris. They are the 1967 Outer Space Treaty and the 1972 Liability Convention. Article 7 of the Outer Space Treaty provides that a launching state is internationally liable for damage caused by a space object that belongs to its public or private entity. The treaty does not contain any direct reference to space debris. However, space debris is considered to be a space object. The 1972 Liability Convention expanded the provisions of the Outer Space Treaty. The launching state is internationally liable for damage caused by its space object to another state or to its nationals or juridical persons. Unlike general international law, under international space law, state is liable for damage caused by both active space objects and space debris, as well as the damage caused by objects belonging to its private companies. In order to hold a state liable in such cases, there is no need to establish the damage causing act is attributable to that state. Depending upon where the damage took place, liability of a state may be absolute or fault-based. A launching state is absolutely liable for damage caused by its space object on the surface of the Earth or to an aircraft in flight. A prime example of this is the case of re-entry of the Soviet Cosmos 954. As mentioned earlier, a radioactive debris fell in on the Canadian territory and cause damage to Canadian property. Damage caused to Canada by the crash landed space debris was compensated by Soviet Union. If damage is caused elsewhere, for instance in outer space or a celestial body, the launching state is liable only it is it, if its fault is proved. In other words, the victim of an accident in outer space must prove fault on the part of the state that caused damage. This could be very difficult, especially if the damage is caused by a small piece of debris. The 2009 collision between Cosmos 2251 and Iridium 33 is an example how difficult it is to determine fault. In certain circumstances, a state can be liable for damage caused by space debris under general international law, particularly as provided in International Law Commission's articles on state responsibility. However, in this case, the claimant state must meet the main criteria as mentioned in these articles. That is, the alleged internationally wrongful act of state consists of an action or omission when it is attributable to the state under international law and consists a breach of international obligation um, of that state. Having outlined the law, it can be said that lex lata is limited in scope and only addresses the legal consequences of damage from space debris. Attention should also be turned to the legal or political commitments to prevent the growth of space debris and risks associated with such debris. Since the late 70s, the international community has been searching for some preventive measures to resolve space debris problem. One of the main efforts in this regard has been the adoption of space debris mitigation guidelines, first by the Interagency Space Debris Coordination Committee, and later by United Nations Committee on the Peaceful Uses of Outer Space, COPIUS. The COPIUS guidelines provide that in mission planning, design, manufacturing, operational phases of spacecraft and launch vehicle, an operator should consider inter alia the following main guidelines. Should limit debris releasing, the releasing of the debris during operational phases. Minimize the potential for breakup during operational phases. Limit the probability of accidental collision in orbit. Avoid intentional destruction and other harmful activities. Minimize potential for post-mission breakup resulting from stored energy. Though these guidelines are instructive in providing a standard for reducing and mitigating space debris during the launch, mission, and disposal of space objects, they have limitations. COPIUS guidelines apply only to mission planning and operation of newly designed spacecraft. The guidelines do not deal with disposal of debris currently orbiting in space. COPIUS guidelines are not legally binding under international law. This means there is no legal obligation for states and space operators to comply with these guidelines. Unfortunately, a series of significant debris-creating events involving both intentional and unintentional breakup of large space objects have occurred since 2007, since these guidelines were adopted. They, in fact, have undone any debris reduction that achieved by COPIUS guidelines. Years of successful mitigation can be negated by a single large event. Overall, we are not doing very well. The COPIUS guidelines are general recommendation to be implemented by states through national legislation, regulation, or policy directives. Some states have adopted domestic policy and legislation regulation that implement copious guidelines to commercial, civilian, or military space actors. For example, the Canadian Space Agency has adopted the space debris mitigation guidelines in order to mitigate the potential creation of space debris generated by its projects, missions, and activities. Such similar legal and regulatory steps can be found in the national legislations of some other states. So what should more be done? What should be Lex Defender? The purpose of the copious guideline is to limit the generation of new debris. In view of massive amount of debris already in space, growing consensus among experts is that in addition to mitigation um, efforts, an active process for removal of existing debris must be undertaken. Various technical concepts, means, and capabilities are currently being developed or considered for active debris removal. However, the removal of space debris raises a number of difficult economic, strategic, institutional, legal, and regulatory challenges. Firstly, the removal of small pieces is currently not technically feasible and not economically viable. Thus, the focus should be on the removal of large objects which are capable of causing catastrophic collision and massive fragmentation in space. Secondly, space debris removal technologies are dual use technologies and have very significant strategic and military implication because they can be used as anti-satellite weapons. Thirdly, the state of registration holds jurisdiction and control over a space object, including space debris. If a state or a state licensed actor wishes to remove a piece of debris, it can only do so legally if it has the legal jurisdiction and control over that object, or with the prior permission of the state of registry. Fourthly, several countries have established national regulatory regimes that impose a restriction on the transfer of jurisdiction and control over their space objects to parties in foreign countries. The US regime of international traffic in arms regulations, generally known as ITARs, best exemplifies such legal and regulatory restrictions. If a foreign state or company wants to remove a piece of debris with American technologies, it can do so only with the prior permission of the government of the United States. So, to conclude this very brief overview of various practical and legal challenges posed by space debris, it is safe to say that space is a shared global commons which offers unimaginable economic, social, and status benefits. However, the use of space is steadily becoming more dangerous and difficult due to rapidly increasing space debris. In the long run, in my view, it is desired to have an international legal framework treaty. The treaty should also establish an international organization for the purpose of actively removing existing space debris. The debris should, the treaty should allow public and private companies to financially contribute as shareholders. I thank you very much for your attention.
Thank you so much, Professor Jakhu. That was extremely interesting. And now I have a few general questions to go through. You brought up a number of thought-provoking matters in your presentation. How does the faculty present students with the ability to study these issues?
Over time, we have developed a unique approach to study of space law. A sample of that approach is exhibited in my presentation. I covered technical and practical aspects of space debris, applicable general international law. I covered international space law. I covered national law. I covered lex lata. I covered lex defrenda. This approach has been dubbed as, generally is dubbed as McGill model of space law education. We should keep in mind space is a unique body of law that governs outer space and outer space activities. Such activities are carried out with the use of highly advanced and complex technologies to meet various earthly, economic, social, political, cultural needs pursuant to relevant policies. Space law is not an independent or detached branch of law. It comprises of concepts, principles, rules derived from different fields of law that might be applicable to space activities and an outer space domain. For example, as international space law is embedded in general international law, so by implication, whenever space activities are have a bearing on environment, environmental law principles become relevant. Similarly, when teaching about national space laws and regulation, it's imperative that students are reminded of the adoption and application of national laws and regulation according to the respective their constitution or legislative processes. This holistic approach in teaching, learning, researching, and practicing space law has been initiated at McGill since the 80s and has now been recognized and being promoted by the United Nations. So that's what we offer to prospective students to McGill.
Now, McGill offers a Master of Laws, Doctor of Civil Law, and Graduate Certificate in Air and Space Law. When you're on our admissions committee reviewing files for the faculty, what do you look for in LLM and DCL applications? What makes an applicant stand out?
For LLM degree, it's important to provide a personal statement expressing clearly the rationale for specializing in the air and space law fields. It's useful to indicate if the applicant has professional experience in these fields. DCL, Doctor of Civil Law, is an advanced research degree. The most important document to be supplied by an applicant is a very well drafted his or her research proposal. The proposal must clearly indicate research question, appropriate methodology, and more importantly, it must show how his or her research will make original contribution to knowledge. It is useful to indicate if the applicant has research experience, has publications in peer-reviewed journal, etc.
That's all really useful information. Now, the Institute of Air and Space Law is an extremely vibrant environment for our graduate community. When admitted, what opportunities do students have to engage with the Institute of Air and Space Law? For example, are there research assistantships, conferences, workshops, moot court competitions available?
Since 2004, the Institute has received over $6 million for research, student support, and outreach activities. This is the largest financial sponsorship for any air and space law institution in the world. With this, we produce unprecedented results that include the convening of over more than 60 conferences, workshops in Montreal and in many other countries. Around 200 books, monographs, major studies, and papers were published and presented around the world by students and faculty members. The Institute has undertaken research and consulting assignments from various governments and other institutions. In some cases, we reviewed the Canadian federal laws. Our students are, have always been involved in all these activities. Currently, as you mentioned in your introduction, uh, we are working on a complex project, visa project, a Milamos project. Several of our students are working as research assistants, and one of our doctoral students is the research coordinator for this project. Every year, the Institute sends McGill teams to Manfred Lach's Space Law Moot Competition and Sarin International Air Law Moot Court. Our students are encouraged and supported for participation in these moot competitions. In addition, students work as assistant editors for our flagship publication, Annals of Air and Space Law.
So many opportunities to engage with the Institute. Lastly, here's a question that comes up quite a bit. After finishing the LLM or DCL program, what types of careers do graduates pursue?
I want to make a point. I have been talking mainly on space law because that is my field of expertise. And, and it should be kept in mind our space law section or space law curriculum is around 40% of our activities at the Institute. The remaining 60, even I would say 65% activities of the curriculum is devoted to air law. So the Institute of Air and Space Law has very good expertise, as good or even better than space law in the aviation law field. That we should keep in mind. And it is very well known that LLM or DCL degrees from the Institute of Air and Space Law are very well recognized, respected, and desired around the world. Since its inception in 1951, the Institute produced more than 1,200 graduates from more than 120 countries. By the way, if I can say, the Faculty of Law's graduate program was started by the Institute exactly 70 years ago. In 1996, the Institute became the only educational institution in the world to receive from the International Civil Aviation Organization the most prestigious Edward Warner Award for its groundbreaking achievements in the field of air law. Our graduates fill some of the most eminent professional positions around the world. Most of the graduates with LLM degrees from the Institute work for law firms, airlines, space companies, and the governments. More than half of the graduates with DCL degrees work with the airlines, space companies, the governments. Only the remaining, that's less than half of the graduates with the DCL degrees from the Institute go for teaching positions. Finally, I would like to add that Institute's curriculum, teaching approach, research methodology, and outreach activities are specially designed to meet specific needs of our graduates from around the world. In my view, at McGill, we have neither purely academic nor training institution, but towards a leading educational program of hard learning, a specialized field of air and space law.
Thank you so much again for agreeing to participate in this webcast with us. To everyone watching, if you have any questions about our Master of Laws, Doctor of Civil Law, or graduate certificate programs in air and space law, please don't hesitate to reach out. You can consult our website at mcgill.ca/law. Just click on graduate programs at the top. You can also send us an email at grad.law@mcgill.ca. Thank you again for watching today.